Hello and welcome to another episode of All Things Labor Law. And today we're going to talk about the Unemployment Insurance Fund. And we're basically going to talk about the Unemployment Insurance Act of 2016, which is the new amendments. And I'm going to basically break down and draw a comparison between the old Act of 2001 and the new amended Act of 2016. I'm going to demonstrate and have a comparison between the two in a manner that you can understand and how you will benefit from this service. Don't forget to like and subscribe, and feel free to leave comments if you have any questions or clarity. I'll be make sure to reply to your comments. Thank you. Okay, so now we're dealing with the Unemployment Insurance Amendment Act of 2016, and Section 3 deals with exclusions. In the Unemployment Insurance Act of 2001, which is the old act, the exclusions were employees working less than 24 hours, employees earning commission, employees on the learnership, and then public servants, foreign nationals, then also members of parliament, cabinet ministers, and municipal councillors. In the new act of 2016, the exclusions are employees working less than 24 hours, employees earning commission, members of parliament, cabinet ministers, and municipal councillors. The difference between them is employees working on the learnership, public servants, and foreign nationals, they are now included and no longer excluded. Now, just as a side note to all public servants, the government has 1.7 million public servants, and now this act has came into law, of which now they have to deduct UIF for each and every public servant. Now the Department of Labor has approached Treasury, because remember now this is now enacted and is promulgated and is now the law of the country. So anyway, yes, they went to Treasury and asked Treasury whether they can start deducting the UIF now from the public servants, and the Treasury has indicated that they don't have the funds to deduct UIF. So the UIF Commissioner has taken the decision not to deduct UIF from the public servants, because it wouldn't be fair if both parties don't contribute equally. So they came up with an arrangement, or an agreement if you like, that the Department of Labor will now bill Treasury each and every time a public servant goes on retirement and claim for their UIF benefits. And now we're going to Section 5. Now this was not in the Principal Act, but now something has been included there, of which is Section 5, subsection D, and I think involves all benefit types. And it says that to make provision for refinancing of the unemployment insurance beneficiaries to facilitate re-entry into the labor market. And now what that means, to simplify it, is that it will fund skill-based programs while the beneficiaries are still employed. That's all basically what it means. And now we're going to Section 13, also dealing with all benefit types. And it says that the credits were calculated at the rate of 6:1 ratio in a 4-year cycle from the date of application up to the maximum of 238 days. Now, Section 13, subsection 3, also relating to all benefit types, the credits are calculated at the rate of 4:1 ratio and in a 4-year cycle from the date of unemployment up to the maximum of 365 days. Okay, so now the difference is there, that notice the date of application and notice the word unemployment. So it's more beneficial that the calculation is from the date of unemployment, because if you look at the application date, that's gonna negatively affect you now, because let's say your end date was the 31st of January and you only come to apply on the 5th of April, then it means you will lose some credits. But the new act basically says here that it's from the date of the unemployment, so which means you're going to get your maximum credits from the Department of Labor, and you're actually going to get more money because it's actually now 365 days. Now, okay, I'm just going to explain what the 238 days and the 365 days is all about. And that basically is what is known as a credit day. Now, the 6-to-1 ratio and the 4-to-1 ratio, that means that for every 6 days that you work, you have accumulated 1 credit day. Now the new act says now you only work 4 days and then you accumulate 1 credit day. And if you're going to go over a 4-year cycle, that comes to 365 days. Less any days of benefits received by the contributor during the period, except in a case where there was a maternity claim in the last 4 years, and that is delinked. Now the new act talks about the credit claimed in the 4-year preceding the date of application will be subtracted, except in the case where there was a maternity claim in the last 4 years. Section 14 talks about you're not entitled to benefits if the contributor was receiving benefits from the compensation fund. Now COID stands for the Compensation for Occupational Injuries and Diseases. Yeah, so like I was saying, that you were not entitled to unemployment benefits fund, which was established by the Bargaining and Statutory Council. Now in the new Act of 2016, this section in the Act has been deleted. Contributors are now entitled to benefits while in receipt of benefits from the compensation fund or any other employment insurance establishment by a bargaining or statutory council. Just to break that down for you, what that means is that, let's say you had an injury on duty and the compensation fund was paying you any monies. Let's say you broke a leg or you lost a finger and they were paying you monthly payments for that because you have a disability. And you have now stopped working. Now you claim for UIF and they've picked up that you have this monies from the compensation fund. Previously, they were not going to pay your UIF. But now the benefit for you as a client now is that even if you are getting monies from the compensation fund, you are also entitled to get UIF as well. Even if you were getting UIF from other statutory council, you will still get your UIF. Now we're moving on to section 17, and that is unemployment benefits. It means the ordinary benefits. Now then, previously, the application must be made within 6 months from the date of termination, and now it has changed now. The period is extended from 6 months to 12 months for the unemployment benefits. So section 20, it relates to illness benefit type. Now the Act says a contributor is entitled to illness benefit if they are ill for more than 14 days. Now the new part of the amendment says that a contributor is only entitled to illness benefit if they are ill for now only 7 days. So that's the distinctive difference between the two. And then we move on to section 24, which deal with maternity benefits. Now the Act says a contributor who had a miscarriage, stillbirth in the 3rd trimester is entitled to maternity benefits for 6 weeks, 42 days after the miscarriage or stillbirth. Now the new Act says that a contributor who had a miscarriage or stillbirth in the 3rd trimester is also now entitled to maternity benefits for 121 days. And then there's another part that was not in the Principal Act, but now what is included now is that section 24, subsection 6, also relating to maternity benefits, says that a contributor must have worked at least 13 weeks, 91 days in the year before the date of application. Okay, continuing with section 25, maternity benefits, a contributor can apply anytime before or after the childbirth, provided that the application is made within 6 months after the childbirth. Now the amendment version says that a contributor can apply anytime before or after childbirth, provided that the applicant is made within 12 months after the childbirth. Okay, continuing with section 25, that relates to maternity benefits, it says that there was an option to appeal the 8-week and after the 6 months. Now the new Act says that the option to appeal has been removed or waived if the application is submitted after the 12th month. Okay, just to explain that part is that if you made an application after 6 months, you can lodge an appeal giving your reasons as to why you were late in the old act. But unfortunately now in the new act, the option to appeal has been removed now. You cannot appeal anymore if you submit your application after the 12th month, because they have extended for that reason. They give you an extra 6 months to apply now. If you now take longer than that, then obviously they take it out. And that is the reason for that, is for them to not waste time on old applications, but yet to process applications that is coming in, let's say, on a thick and fast basis. Now, Section 30 deals with dependent benefits. Dependent benefits is basically death benefits. The person that is going to apply when they, in which the dependent may apply, one of the parents has died and now the dependent is going to apply. That is basically what it means. And the Act says that the period in which the department may apply for benefits on behalf of the deceased is 6 months. Now the new Act said it is extending the period in which the dependent may apply for benefits on behalf of the deceased from 6 months to 18 months. So that is quite significant. Just remember now, you have a full 18 months to apply now for death benefits. And the new thing that is also added in the Act is, with regards to death benefits, is the nomination of beneficiaries by the contributor was not in the Principal Act, but now in the new Act of 2016, it has now been included. And it basically says nominations of a beneficiary by the contributor of Section 30 is further amended by the insertion of a new provision allowing contributors to nominate their beneficiaries in case of death benefits. Because previously what happened there was only 2 people that basically could apply for the deceased benefits, and that was only in the case of a life partner or a spouse. But now in this case, they have included a nomination. So it means before the person passes away, just nominate somebody by your employer in the event that you pass on, similar to any other death benefit policy. Now the unemployment insurance works similarly. And then another benefit type with regards to the dependents benefit, which was not in the Principal Act, was as follows. Any nominated beneficiary will qualify for benefits if there is no surviving spouse, life partner, or dependent children of the deceased contributor. Watch out for our next video that we will talk about is the contentious issue of the paternity leave. Now I'm going to put that matter to rest for you. There's so much debate out there, and when you watch that video, I will put your mind to rest and you'll get the 100% facts of that piece of legislation. Thank you very much.